Welcome back, everybody, to Cracking the Code 3rd edition. Today we are reading the M and the N of the Glossary. Let's get started. Maker. Maker means a person who signs or is identified in a note as a person undertaking to pay. UCC 3-1-1035. The person who creates or executes a note, that is, issues it, and in signing the instrument makes a promise of payment contained therein, one who signs a check. In this context, synonymous with drawer, black 6th. Man, a human being. This definition includes not only the adult male sex of the human species, but women and children. Examples of offenses against man. Some are more immediately against the king, others more immediately against the subject. Hawk PC Book 1, C2, S1. Offenses against the life of man come under the general name of homicide, which in our law signifies the killing of a man by a man. In more confined sense, man means a person of the male sex, and sometimes it signifies a male of the human species above the age of puberty. It was considered in the civil or Roman law that although man and person are synonymous in grammar, they had a different acceptation in law. All persons were men, but all men, for example slaves, were not persons, but things. Bouvier 6th. Maritime, pertaining to navigable waters, that is to say, to the sea, ocean, Great Lakes, navigable rivers, or the navigation or commerce thereof, black 6th. Maritime jurisdiction. Jurisdiction over maritime causes is granted to federal district courts. Procedure in maritime actions is governed by the Federal Rules of Civil Procedure and Supplementary Admiralty Rules, black 6th. Maritime law. That system of law which particularly relates to commerce and navigation, to business transacted at sea or relating to navigation, to ships and shipping, to seamen, to the transportation of persons and property by sea, and to marine affairs generally, black's 4th. Okay, that which the Congress has enacted or the federal courts sitting in admiralty or in the exercise of their maritime jurisdiction have declared and would apply. Substantively in the United States, it is federal law, and jurisdiction to administer it vested in the federal courts, though not to be entirely to the entire exclusion of the courts of the states. Black 6th. Mark. A license to make reprisals. See letter of mark. Wagnalls. Number 1, a noun. A symbol, impression, or feature on something, usually to identify it or distinguish it from something else. Number 2, trademark. 3, service mark, black 7th. Compare mark, letter of mark, mark of the beast, service mark, trademark. Mark of the beast, and that no man might buy or sell, say he that had the mark, or the name of the beast, or the number of his name. Revelation 13:17, New Testament. See note, Gentiles, note, had goods. Note, the word mark is synonymous with mark, and both words have the same etymology. A common definition of the two is a license of reprisal. The definition of license in Black's first is, in international law, that is to say, trade or commerce, permission granted by a belligerent state to its own subjects or to the subjects of the enemy to carry on a trade interdicted by war. As we have seen in the Amendatory Act of March 9th, 1933 to the Trading with the Enemy Act of October 6, 1917, see Trading with the Enemy Act of October 6, 1917, and license. Quote, citizens of the United States, unquote, are legally classified as enemies of their own government. To do business with its new enemy, the U.S. government thereafter instituted wholesale licensing and issued marks or licenses to the subjects of the enemy to carry on a trade interdicted by war, thus enabling American men and women to buy or sell and otherwise engage in trading with the enemy despite being at war. The chosen masters considered you nothing more than an animal, a beast, see Gentile, to be birthed and bred, herded and harvested, and sold and slaughtered as they see fit. For you, as a beast, to be identified and validated and permitted to buy or sell in today's industrial society, you must have a special mark without which you are not allowed to participate. It is interesting that the word mark is also synonymous with the terms service mark and trademark. The special marks used to identify and distinguish the services of a certain provider, the products of a certain manufacturer or seller. See note at goods. Mark. Mark A? Let's say mark. A capital, a letter of reprisal on an enemy, as at sea in wartime, chiefly in the phrased letter of mark. See letter of mark, compare mark. Maternity Act of 1921, see note. Note, in 1921, the Federal Maternity Act created birth registration, or what we now know as the birth certificate. It was known as the Maternity Act and was sold to the American people as a law to improve maternal and infant mortality, for protecting the health of mothers and infants, and for other purposes. One of those other purposes provided for the establishment of a federal bureau designed to cooperate with state agencies in the overseeing of its operation and expenditures. The Maternity Act was eventually repealed, but parts of it have been found in other legislative acts. Maxims of commerce. Ooh, this is very important. Note, commerce is antecedent to and more fundamental to society than courts or legal systems, and exists and functions without respect to courts or legal systems, but not vice versa. Commercial law, the non-statutory variety, has presented below in 10 maxims 1 through 10, and the economic extension of natural law into man's social world, and is universal in nature. The foundational, invariant, necessary, and sufficient principles for maxim of commerce are: 1. A workman is worthy of his hire. See Exodus 20, verse 15, Leviticus 19:13, Matthew 10:10, Luke 10:7, 2 Timothy 2:6. Legal maxim: it is against equity for free men not to have free disposal of their own property. 2. All are equal under the law, God's law, moral and natural law. Exodus 21:23 through 25, Leviticus 24:17 through 21, Deuteronomy 1:17, chapter 19, verse 21, Matthew chapter 22, 36 through 40, Luke 10:17, Colossians 3:25. Legal maxims: no one is above the law. Commerce by the law of nations ought to be common, and not to be converted into a monopoly and private gain of a few. 3. In commerce, truth is sovereign. Exodus 20:16, Psalms 117, verse 2, John 8:32, 2 Corinthians 13:8. Legal maxim: to lie is to go against the mind. Oriental proverb: of all that is good, sublimity is supreme. 4. In truth, truth is expressed by means of an affidavit. Leviticus 5:4-5, Leviticus 6:3-5, Leviticus 19:11-13, Numbers 30:2, Matthew 5:33, James 5:12. 5. An unrebutted affidavit stands as truth in commerce. 1 Peter 1:25, Hebrews 6:13-15. Legal maxim: he who does not deny admits. 6. An unrebutted affidavit becomes a judgment in commerce. Hebrews 6:16-17. Any proceeding in a court, tribunal, or arbitration forums consists of a contest or duel of commercial affidavits wherein the point remaining unrebutted in the end stand as the truth and the matters to which the judgment of the law is applied. 7. A matter must be expressed to be resolved. Hebrews 4:16, Philippians 4:6, Ephesians 6:19-21. Legal maxim: he who fails to assert his rights has none. Number 8. He who leaves the field of battle first loses by default. Book of Job. Matthew 10:22. Legal maxim: he who does not repel a wrong when he can occasions it. Sacrifice. Number 9. Sacrifice is the measure of credibility. One who is not damaged, put at risk, or willing to swear an oath on his commercial liability for the truth of his statement and legitimacy of his actions has no basis to assert claims or charges, and forfeits all credibility and right to claim authority. Acts 7, life and death of Stephen. Legal maxim: he who bears the burden ought also to derive the benefit. 10. A lien or claim can be satisfied only through rebuttal by counter-affidavit, point for point, resolution by jury, or payment. Genesis 2-3, 4, or Matthew 4, Revelation. Legal maxim: if the plaintiff does not prove his case, the defendant is absolved. Because truth is sovereign in commerce, and everyone is responsible for propagating the truth in all speaking, writing, and acting, all commercial processes function via affidavits certified and sworn on. Each affiants commercial liability as true, correct, and complete, attesting under oath the validity, relevance, and veracity of all matters stated and likewise demanded, usually in written matters such as on an IRS Form 1040, 8300, etc., voter registration application, driver's license application, notary form or document certification, application for a Treasury Direct account, and on nearly every document that those who run the system desire anyone to sign in a commercially binding matter. Signature is required under penalty of perjury, true, correct, and complete. In a court setting, however, testimony, oral commercial affidavit is stated in the judicial equivalent by being sworn to be the truth, the whole truth, and nothing but the truth, so help me God, as well as the need for asserting all matters under solemn oath of personal, commercial, financial, and legal liability for the validity of each and every statement. Participant must provide material evidence, that is to say ledgering, bookkeeping, substantiating that each fact or entry is true, valid, relevant, and verifiable. Without said acceptance of liability and facts provided to support one's assertions, no credibility is established. Inasmuch as commerce existed before and can continue to exist irrespective of courts and legal systems, but not vice versa. Commerce is a more fundamental aspect of life than courts and legal systems. Medium of exchange. A substance used to transfer energy from one source to another. Mission. A definite task assigned to an individual or unit of the armed forces. Funkenwagnalls. See note. Note. Apparently, Department of Treasury, IRS, BATF, SEC, etc., and other quasi-governmental and governmental agencies are de facto military units because they each operate off a prescribed mission. Mixed war. Mixed war is war carried on between a nation on one side and private individuals on other. See note mixed war in appendix. Compare dualocracy. Note, mixed war occurs when the government of a nation is an enemy of and at war against its own people. The most insidious and perfidious type of mixed war exists when the government acts against the people under guise of protecting the people's rights and upholding the nation's most cherished values and ideals. In such case, government officials are wolves in sheep's clothing, occupying positions of prestige and power with the support of the people while treasonously betraying that trust. This is an ideal confidence game whereby arch charlatan criminals are engaged in piracy on an ongoing basis under color of law and be tolerated or even treated as heroes by their victims. Money. Money means a medium of exchange authorized or adopted by government. UCC 1-20124. See note. Note, before the 1933 bankruptcy of the U.S. government, money consisted of gold and silver species, as well as their equivalent in certificate form. Gold, which is portable land substance, is the money of sovereigns. Fiat money, that is to say money by decree, or monopoly money, is the money of the artificial persons called banks, corporations, governments, trusts, and individuals. Monopoly is a trademark. A board game in which a player attempts to gain a monopoly of real estate by advancing around the board and purchasing property, acquiring capital by collecting rent from those players whose pieces of land on his property. See note, Federal Reserve notes. Note, first copyrighted in 1935 by Parker Brothers. Logo includes the caricature of an English banker replete with top hat, tails, and cane, another allegorical clue from the powers that be as to what is actually going on, monopolization of all ownership of real estate, land, and wealth. The objective in the game of Monopoly is to drive into bankruptcy all other players, an arrangement otherwise known as a tontine wagering scheme. If you examine the nature of economics in America today, you will see that all land is owned by the state. See Senate Document 43, 73rd Congress, First Session. Everyone is competing for the same fixed amount of monopoly money, called Federal Reserve notes, and attempting to stay above water and avoid bankruptcy. This is, by definition, a de facto state of war between participants in both the board game and the game of life. The only way to stay in the game of Monopoly and avoid bankruptcy is to obtain more Monopoly money than other players. The only way to stay in the game of life and avoid bankruptcy is to somehow obtain more Federal Reserve notes, that is, acquire more liability and debt instruments and debt called money from those around you. Totina, after its inventor Lorenzo Tonti, Neapolitan. A financial arrangement in which a group of participants share in the arrangement's advantages until all but one has died or defaulted, in which time the whole goes to that survivor. Monster. A human being by birth, but in some part resembling a lower animal. A monster hath not inheritable blood and cannot be heir to any land. Ballantyne's Law Dictionary, 1930. A prodigious birth. A human birth or offspring not having the shape of mankind, which cannot be heir to any land, albeit brought forth in marriage. Black's Verse, see note. Note. Under human being, Ballantyne says only see monster. Neither of the above major law dictionaries define human being, rather only monster. Mortgage. Mortgage means a consensual interest in real property, including fixtures which secure payment or performance of an obligation. UCC 9-102A55. See note. Mortgage. Another. Gift of Norman French attorneys comes from the French mort, meaning dead, and gage, meaning pledge. Dead pledge. For example, that is to say, killing of the pledge through payment. Okay. Name. Names are divided into Christian names. Okay, here we go on to the ends. Names are divided into Christian names as Benjamin and surnames as Franklin. So Benjamin Franklin. No man can have more than one Christian name, though two or more names, usually kept separate, as John and Peter, may undoubtedly be compounded so as to form, in contemplation of law, but one. A letter put between the Christian and surname as an abbreviation of a part of the Christian name, as John B. Peterson, is no part of either. Bouvier 6th. Natural law. Natural law is law which so necessarily agrees with the nature and state of man that without observing its maxims, the peace and happiness of society can never be preserved. Knowledge of natural laws may be attained merely by the light of reason, from the facts of their essential agreeableness from the constitution of human nature. Natural law exists regardless of whether it is enacted into positive law, although there may be instances where natural law cannot be judicially enforced. Barron's 3rd. Natural person, a human being as opposed to artificial or fictitious persons, such as corporations. The phrase natural person does not include corporate entities, but the phrase person, without qualification, may or may not include artificial persons, depending on the context. Thus, the phrase no person in the 14th Amendment's Equal Protection Clause has been held to include natural or artificial persons, but the same phrase no person in the 5th Amendment's Privilege Against Self-Incrimination Clause has been held to include only natural persons and not corporations, since the privilege is personal and may not be asserted by an artificial person. Barron's 3rd. See note. Note, this is how the IRS justifies insisting that flesh and blood men and women testify against themselves. People answer up when the name of their fictitious trade name is called, and the IRS enforces its commercial agenda against people by treating them like their trade name. The above definitions is enlightening, but it is taken from the Law Dictionary. Please realize that in the scheme of life, it is just as impossible for a person to be natural as it is for man to be artificial. Nature and clause seen above, see below. Nature, a fundamental quality that distinguishes one thing from another, the essence of something. Black 7th, see note. Cause, that which produces an effect, whatever moves, impels, or leads, the origin or foundation of a thing, as of a suit or action, a ground of action. Black's 1st, see note. Note, the right of an accused party to be informed of the nature and cause of any criminal accusation is secured by the 6th Amendment of the Constitution. This term concerns the two absolutely essential elements necessary to establish claims, charges, and demands as commercially and lawfully valid, both criminal and civil, and without which any matter affirmed is devoid of credibility and legal force and effect. Nature. The nature of an accusation is the proof, that is to say, ledgering, bookkeeping, set forth with a one-to-one accounting of goods or services provided, or offenses committed, with corresponding monetary values, with each and every matter established by affidavit sworn to the commercial liability of the executing party. Cause. Only individual free will men and women can act. Nations, governments, and agencies cannot act. At the origin of each and every allegation and act is the man or woman who is the cause thereof. The cause of an accusation is therefore the particular man or woman who can initiate allegations, claims, and charges, and credibility of which is established by the degree of commercial liability and alleging party stakes on which he or she asserts. By initiating something that can cause another harm or loss, the alleging party simultaneously agrees to be held personally, legally, and commercially accountable and liable for the accuracy, validity, relevance, and verifiability of everything stated, claimed, and demanded in the affidavit. The degree of credibility of alleged statements, claims, and charges is established by the extent of the liability the accuser places at risk to be forfeited in an event anything he or she states is untrue in accordance with the commercial maxim. Sacrifice is the measure of credibility. Negotiable. Negotiable means that which is capable of being transferred by assignment, a thing which may be transferred by a sale and endorsement or delivery. Brack's 1st. Adjective, of bills, security, etc. Transferable by delivery with or without endorsement, according to the circumstances, the title passing to the transferee. Webster's. Negotiable instrument, a writing which is signed by the maker or drawer, contains an unconditional promise or order to pay a sum certain in money, is payable on demand or at a definite time, and is payable in order or to bearer. Baron's 3rd. A. Except as provided in subdivisions C and D, negotiable instrument means an unconditional promise or order to pay a fixed amount of money with or without interest or other charges described in the promise or order. If it is all of the following: 1. It is payable to bearer or to order at the time it is issued or first comes into possession of a holder. 2. Is payable on demand or at a definite time. 3. Does not state any other undertaking or instruction by the person promising or ordering payment to do any act in addition to the payment of money. But the promise or order may contain: 1. An undertaking or power to give, maintain, or protect collateral to secure payment. 2. An authorization or power to the holder to confess judgment or realize on or dispose of collateral, or 3. A waiver of the benefit of all law intended for the advantage or protection of the obligor. B. Instrument means a negotiable instrument. C. An order that meets all requirements of subdivision A, except paragraph 1, and otherwise falls into, with the definition of check in subdivision F is a negotiable instrument and a check. D. A promise or order other than a check is not an instrument if, at the time it is issued or first comes into possession of a holder, it contains a conspicuous statement, however expressed, to the effect that the promise or order is not negotiable or is not an instrument governed by this division. UCC 3-104. A negotiable instrument is a written promise or request for the payment of a certain sum of money to the order or to the bearer. A general name for bills, notes, checks, transferable bonds or coupons, letters of credit, and other negotiable written securities. Blacks first. See note. New debtor. New debtor means a person which becomes bound as debtor under subdivision D of section 9203 by a security agreement previously entered into by another person. UCC 9-102A56. Nobility. An order of men in several countries to whom privileges are granted at the expense of the rest of the people. Bouvier 6th. Nobility. 1. Persons of social or political preeminence, usually derived by inheritance or from the sovereign. Black 7th. The Constitution of the United States provides that no state shall grant any title of nobility, and no person can become a citizen of the United States unless he has renounced all titles of nobility. The Federalist, number 84, second story, Laws, U.S. 851 Bouvier 6, 1856. Note, judges and attorneys hold a British title of nobility from the crown and act as squires or shield bearers for and between the king or queen and those whom the king or queen wishes to engage in battle. Nom de guerre. Nom. Used an expression denoting a pseudonym, a false or assumed name. Oxford English Dictionary, nom de guerre. Nom de guerre. French. War name, a fictitious name. Literally, war name, a name assumed by or a name assigned to a person engaged in some action or enterprise. Note, any fictitious name is a war name or nom de guerre. The U.S. government, formally at war with you since the Amendatory Act of March 9, 1933, to the Trading with the Enemy Act, October 6, 1917, used the legal fiction artifice of the right to presume on your behalf and assigned you a false name, a war name, in the form of your all capital letters, strawman name, your war name, trade name, nom de guerre, trade name. See legal fiction. Non-negotiable, not negotiable, not capable of passing title or property by endorsement and delivery. Blacks first. Any document of title that is not a negotiable document, an instrument which may not be transferred by endorsement and delivery or by delivery alone, though it may be assigned. Black 6. See note, negotiable. Note, the word non-negotiable appearing on what might otherwise look like a negotiable instrument signifies that 1. The contract is not negotiable and strictly private. 2. Both between drawer and drawee and obligor and obligee only. And 3. The debtor payee may pass title or transfer the document neither by delivery nor by endorsement, but only through assignment. See drawing preferred stock. Non-prosecutor, prosecutor. Okay, non-prosecutor, prosecutor. He does not follow up or pursue. If, in the proceedings and action at law, the plaintiff neglects any of those steps which he ought to take within the time prescribed by the practice of the court, for that purpose the defendant may enter judgment of non-pros against him, whereby it is adjudged that the plaintiff does not follow up, non-prosecutor, his suit as he ought to do, and therefore the defendant ought to have judgment against him. Under current rules practice, such failure would result in the dismissal of the action or default judgment or defendant. Federal Rules of Civil Procedure 41, 45, Black 6. See note. Note, when any plaintiff fails to respond as required under the principle of non-prosecutor, the defendant may enter judgment for dismissal for plaintiff's failure and follow-up as he or she should. Public notary, a public officer whose function is to attest and certify by his hand and official seal certain classes of documents in order to give them credit and authenticity in foreign jurisdictions, to take acknowledgments of deeds and other conveyances and certify the same, and to perform certain official acts, chiefly in commercial matters such as the protesting of notes and bills, the noting of foreign drafts, and marine protests in cases of loss or damage. Blacks first. An officer appointed by the executive or other appointing power under the laws of different states, their duties are generally prescribed by such laws, the most usual of which are 1. To attest deeds, agreements, and other instruments in order to give them authenticity. 2. To protest notes, bills of exchange, and the like. 3. To certify copies of agreements and other instruments. Bouvier 6. Notaries are of very ancient origin, and they are well known among the Romans and exist in every state of Europe, and particularly on the continent. Bouvier 6. Their acts have long been respected by the custom of merchants and by courts of all nations. Bouvier 6. Notaries of public are officers of the state, and in some states notaries may become officers of the court as well. The seal of a notary public gives a document credit and authenticity in foreign jurisdictions, that is to say international jurisdiction, hence the apostille. A notary republic performs certain official acts, chiefly in commercial matters. Commerce is prejudicial and non-judicial. Notary publics once played a major role in world commerce and still retain the same powers, though many have fallen out of use since America began using private, non-substance, fiat by decree money, Federal Reserve notes. Note, a writing acknowledging a debt and promising payment for the instrument to be negotiable. It must be signed by the maker and contained an unconditional promise to pay a sum certain in money on demand or at a definite time to order or to the bearer. A note is not payment, but only a promise to pay. Federal Reserve note, I get it. A note is not payment, but only a promise to pay. The term note is synonymous with promissory note. The term may be qualified by its unique characteristics. For example, a note that is backed by a pledge of collateral, such as real or personal property, is called a secured note. Barron's third. All right, come up next is the O's. We'll start those next time. Thanks for listening.